All right. So, a very good evening to all. International Council for Circular Economy welcomes you to the 11th episode of the third season of our Circular Chat. We are extremely excited to be back with another episode on the series of climate change. Hi, I'm Susanna Lal, and I'm happy to host our guest speaker today, Mr. Shawahiq Siddiqui. Today, Mr. Siddiqui and I will discuss about climate litigation and how does climate litigation work. So, Mr. Siddiqui is a people's lawyer deeply involved with the communities impacted by environmental issues and represents them in courts and other forums. So, thank you so much for joining us today, Mr. Siddiqui. Yeah.
Thank you.
So,
Thank you.
yes. So, to begin with, and to set the stage for today's session, Mr. Siddiqui, could you please elaborate on what climate litigation actually is?
Well, thank you for having me once again. And thank you for that little introduction. Now, I am not a lawyer who gets to argue a very fancy case on a policy premise. I'm someone who works more with the communities locally and, for example, the coastal communities and tries to understand how climate impacts is taking their livelihoods. Sometimes with the transboundary communities, for example, India-Nepal border, and tries to understand how they are dealing with the changing river flows and patterns. And from that deductive analysis, see how courts and other forums are responding to these very grim realities that are visible to people on the ground, but not to the policymakers or, so, for example, judges in the court. Now, to my understanding, so far in practice, the way we have been seeing in courts in India and in the neighborhood, I would say, we also have green court, for example, in Bangladesh. Uh, Climate litigation is it is a gray area, very similar to, I would say, the law of torts, for example, where it is very difficult to prove civil liability and damages, though it exists, and the harm may exceed to, multiple levels of harm. So climate litigation, the way we have been seeing, is still something which is evolving. There's a limited capacity of the courts to comprehend climate issues, and hence has been the response. So, for example, in the words of the Green Court in India, the National Green Tribunal itself, the environment impact process itself involves climate change issues. So if you take that definition forward and interpret it to the extent possible, so by that interpretation and virtue, every other case on environment filed under the statutory provisions in India is a climate litigation in India by that definition. But I would say let's push the envelope a little further and try to understand from a few cases in terms of what it means in the country context, and probably if there's an opportunity, let's see if we can see what it means in a transnational context. So there have been, at least in our memory, we have seen 3-4 cases directly filed on climate change in the National Green Tribunal in India, which is the National Green Court. Though there are issues to be discussed in terms of pre-Green Tribunal court cases evoking principles of international environmental law and how do they relate to Kyoto Protocol and Rio and climate change, so on and so forth. But direct cases that one could pick and see what it means to litigate climate change in India and what does climate litigation means by virtue of those cases. So one direct case that emerged was Gaurav Bansal case, where National Climate Action Plan was taken directly in the Green Tribunal, and the contention was that government is not doing enough on National Action Plan on climate change, and states have not responded adequately on that. Now, how did the court respond to it? Well, the court said there is no evidence to say that National Action Plan is not being followed, and there is no evidence to say that states are not doing well. Some states are slow, some states have prepared it, but it is in action. Therefore, the center and state are putting together their action to do. So that was dismissed. Soon after that, another case was filed that Delhi does not have action plan. It was again dismissed, saying that, well, Delhi's prepared action plan, it is fine. The third case was filed by this 9-year-old, rather a pretty famous case, where it was the international law principle of intergenerational equity and rights of generations were evoked, and it was said that, well, government should include climate issues into their policy and planning. It was again dismissed that there is no evidence to suggest that government does not. And within that, there is this statement by the NGT that EIA includes climate change. So two issues arise in terms of understanding. If you look at these litigations and the response of the court, two things very clearly arise. One, climate litigation in India for litigators have meant to take the existing policy to the court and say, well, Paris Agreement is not reflected, Paris climate action is not happening, action plans are not adequate or enough, or governments are not making them. So that's a quote-unquote policy issue taken to court, which is a the convention that normally the policy and the judiciary, they remain separate. Government does not interfere much in the policy making unless the policy provision or the law is challenged. The second outcome of this litigation is that there is lack of evidence on the part of the litigator in India to when these cases are taken or climate litigation is done, if this at all can be called climate litigation. If this is taken to court, there is lack of specificity in the cases on climate change, which can then help the court or assist the court in terms of giving orders that the litigators are desiring. So to my understanding, climate litigation in India is an effort, is an ongoing endeavor, is still a gray area, which is not evolved.
Thank you so much, Mr. Siddiqui, for putting forward many valid points. And I do agree with you that it is still ongoing and in the process. So thank you for that. Moving on, Mr. Siddiqui, we know that climate litigation typically engages in one of the 5 types of legal claims. So could you explain what these are and what each of them entails?
Well, see, I typically do not agree with the premise that climate litigation engages with only 5 types of claims or 6 types of claims. For example, there is, I mean, in the environmental law jurisprudence, the way it has evolved, it is both the criminal component, the criminal liability component, the way EPA talks about it, the Water Act in India talks about it, and there's a compensation which the courts and the tribunals have been more inclined with. So there's a civil liability and the civil compensation part of it, and there's a criminal liability where you have both the imprisonment and the penalty imposed. So the claims as to the climate change issues that arise, the kind of claims that arise, that can go beyond the understanding of 5 or 6 legal claims in terms of compensation, in terms of the damages, in terms of civil liability, in terms of restitution, in terms of the punishment. So I would say there is the unbundling of those claims in climate litigation still has to happen from the perspective of climate change as an issue itself. I'll tell you why. Now, see, again, we come to the fundamental issue is how and where does the claim arise from? How do you litigate? You litigate out of two things. One, either you have a statute under which your legal right has been violated, and you take that violation of legal right as a claim to a court and argue and try and convince the judge to your point of view, saying that, well, my right under so-and-so statute has been violated. Or you claim your right under the wider constitutional guarantee or the wider constitutional spectrum of rights that has been entrusted upon you. For example, Article 21 of the Constitution of India, right to life, which has in fact been responsible for developing a mini constitutional environment. So entire environmental jurisprudence pre 2010, which is NGT Act, was completely developed by the Supreme Court under Article 21. So that is a broad ambit under which each and every case on pollution, whether air, whether water, whether environment, whether wildlife or forest, everything was taken to the Supreme Court under Article 21. In addition to the statute that existed. So these are the two main streams under which you evoke your legal claims or your rights and take typically to a court. So far, climate change is concerned, climate change is still not a statutory right in this country, and I would like to think it is not anywhere in South Asia. I work very closely with, for example, in Bangladesh, in Nepal, in other countries. We have not come across an act where climate change has still been made a statutory right. And therefore, it is a policy at best. In fact, the action plan and policy, you can argue. National Action Plan on Climate Change, or for that matter, the state action plans, are the policies at best, and policies are non-justiciable. So therefore, the issue of claims or a bundle of claims arising out of a policy is difficult to comprehend in law, and policies are non-justiciable, and therefore the response of the courts has been so far. So that would be my understanding, that let's not limit the legal claims to 5 or 6 types of legal claims that exist. Climate change can result in a number of claims that you can think of.
All right. Thank you so much, Mr. Siddiqui. And I think that is very informative, and our audience must have got a better clarity now. So thank you for that. Moving on, Mr. Siddiqui, you were earlier talking about how climate litigation actually works. And we find that, in when it comes to tackling climate change, it is actually vague and unfamiliar. So can you explain, or would you like to elaborate more on how it actually works to tackle climate related issues?
Well, again, a very subjective answer, and I can only exemplify it again with another example. And I'll bring here the transnational issues rather than the national issue, and try and demonstrate how it is very difficult to take a climate claim into a court of law through litigation and seek judges' attention and seek, in fact, an order which, in fact, can favor the climate action on behalf of the government, or in fact pushes the governments to think on those lines. Now, again, India and Nepal share around 6,000 rivers and rivulets. So the very large river systems trickle down from Nepal to India, and we know that some of the areas in Bihar and Uttar Pradesh in India are the most flood affected or flood disaster affected areas in South Asia and in world across, in fact. So what has happened around in the last decade or so, that the intensity and unpredictability of flood related disasters and meandering of rivers has increased. Now the locals, supported by certain lawyers, tried to take it as a legal issue, and putting it within the framework of that, well, this has been exacerbated by the impacts of climate change in the upstream, and there's because of due to oversiltation and cutting of trees, etc., climate change has been aggravated, and therefore water that has been coming traditionally and people have known to deal with it has changed, and therefore government needs to pull up their efforts to put climate policies into action and do something about it. Now it went to the court, and the court simply asked, well, we are willing to listen to you, but show us an evidence, a scientific evidence, where you can say that the pattern of river flow or the impact of floods or the intensity of floods has changed from previous time to this time due to certain human activities or certain natural activities. Now, there is no science at the community level or at the litigant level, or the capacity of litigants affected by these events to bring to the court. So coming back to your answer in terms of how do you deal or how do you tackle with climate claims, it has been rather very difficult to prove in the court that certain claim arises out of the climate change. And I would say, if I were to draw conclusions from all the cases that have touched climate change so far, 5 or 6 direct cases, and a host of cases where if they were not on climate change, at least the orders or judgments of the courts have tried to seek recourse to mentioning of Paris Agreement or recourse to mentioning of GHGs or international conventions, saying that, well, your actions are not in conformity or in conformity with this. So, host of cases. One thing is common in all the cases, that the lack of evidence is one of the biggest barrier in terms of taking a claim to the court on climate change premise. So climate litigation suffers from one fundamental aspect, which is lack of data, lack of evidence showing that certain event or certain claim arises due to climate change. So that's one fundamental area where I think the law of evidence and the courts need to work. Very similar to what we have in the criminal jurisprudence, for example. There is no circumstantial evidence here. As I said, the law of tort does not work fairly here. There is no circumstantial evidence that the courts are willing to listen to. For example, in comparable gas leak case or a disaster case where you can really prove in terms of what has happened. Here you cannot prove what has happened, how it has happened, and therefore the courts have really been reluctant to entertain, so to say, climate litigation.
All right. Thank you, Mr. Siddiqui. You mentioned that lack of data and lack of evidence is some challenges that it faces. But knowing that climate litigation covers a wide ambit of problems over many nations, what are more glaring challenges that can be seen in this pursuit of climate justice?
Uh, many challenges, in fact. Uh,
Hmm.
so, so for example, theoretically, one can imagine that you would want to, for example, sue theoretically and not really the developed countries for GHG emissions because they've been causing a global warming. But realistically speaking, it is in the international context, it is the neighboring countries where the climate impacts will be more closely felt with, and it is the action of, for example, the upstream which greatly affects the downstream or the neighbors affect it. So the gas clouds or the carbon clouds, for example, in Calcutta impacting greatly in Dhaka. So that's the kind of issues that we are seeing in South Asia. Or the pollution, the mining pollution and other pollution, for example, trickling down from Ganges to Bangladesh or trickling down from Meghalaya to Bangladesh, or a lot of pollution coming from rivers from Nepal to India, or for example, a lot of pollution from eastern Punjab to the western Punjab and vice versa. So these are the issues that we are seeing, which are grave in the region, and there is no forum to, number one, address these issues amicably. For example, from the diplomatic or bilateral engagement perspective, there are very less joint institutions which are open to discussing these talks, and if at all there are no legal spaces that support that. Second, there are no joint mechanisms in the neighborhood, for example, in South Asia, which is contiguous, interconnected, hydrologically one, climatically one, connected by Himalayas, and if at all there are climate impact, they will impact us all uniformly. But which act does what, and so there is no, I would say, a collective and joint effort in the region to deal with climate changes. So we have seen that regionally, the forums that we have had traditionally, for example, SARC, did not do progressive work in terms of to keep pace with issues like climate change. Other economic forums that are emerging in the region, for example, BBI and BIMSTEC in South Asia, are not focusing on climate change at all. Bilateral mechanisms are not geared up. We typically deal on an issue-to-issue basis. It is basically the economics at the center, and ecology and climate are have taken a backseat, and therefore these challenges are, suddenly thinking about that whether you will be able to litigate on this. I think that's not the best idea. To accuse one country of uh, having impacted the other country and climate change being the issue, and suing one country on climate change aspects, I think is not the best way forward, because simply in the region in South Asia, where I think we will be having a lot more transnational issues related to climate change, there is very less legal preparedness to deal with even sectoral issues. So water, energy, air pollution, water pollution. I mean, there's very less legal preparedness to deal with this alone. Forget about a very complex issue like climate change. So therefore, The first challenge, in fact, is to recognize the climate impacts regionally, recognize that it can be done collectively, and then have a certain roadmap to deal with it. And if governments fail, then probably the issue of climate change arises. Well, there are, as international law works, you cannot by yourself go to the International Court of Justice and say that a certain country has caused harm and has impacted, and there's a liability arises because of climate change induced by action of certain country. That will be very difficult in the case of South Asia. I would say the challenge is from recognition to action. So that's the curve that countries need to cover in South Asia.
Hmm. Thank you, Mr. Siddiqui. You pointed out the challenges very well, and I hope we do something collectively to tackle the same. So, thank you for that. Moving on, Mr. Siddiqui, if you talk about a particular nation's government, so when the lawsuits are placed against a particular nation's government, how are they held accountable and by who? And the main question here is that are international organizations such as the UN, WTO, are they really effective in holding nations, especially more developed nations, accountable?
Uh, so understand the international justice system, the accountability, of course, but there has to be an understanding between the two countries to take a certain issue to international forum. So whether it is ICJ under 38 or it is the International Court of Arbitration, the Permanent Court of Arbitration, as we understand, or a specific tribunal constituted for a purpose. So there are many international tribunals. You have to have a kind of a joint consensus or an obligation to take a certain issues to ICC. I will give you an example. So India and Bangladesh have for long been, having bilateral cooperation on water issues, the Ganges and other 54 rivers that India and Bangladesh share. Now, one of the key contention between the two countries, and it is very closely related to climate change, has been the augmentation of the flow of Ganges River. And we know that the flow in the Ganges River has been a factor of both the utilization in the upstream, which is in India, and also the climate impacts which the glacier upstream has been facing. So there is a reduced flow and there is more exploitation and use of water within the basin, within the entire basin, and consequently Bangladesh has not been receiving as much as water as it would desire. Now, there is no understanding between the countries in terms of if they do not or are not able to agree to a consensus formula, they can take their contentions to either a permanent court of arbitration or to any other court, for example, ICJ. There is no understanding between the countries. So Bangladesh tried hard around 70s to when it was formed to take this issue to ICJ or to UN, and it failed miserably. Therefore, the way it works is that countries will have to have a kind of a joint understanding. You cannot unilaterally sue a country in an international court. And therefore, the way it works is that there has to be a mechanism in terms of either you have to be guided by the customary international law and the Vienna Convention, or you have to have a specific instrument allowing you to go to. The example could be the Indus Treaty between India and Pakistan, where you have a specific clause that says that the countries fail to come to amicable formula and accuse each other of impacts, any other impacts caused by or damage caused by one country to the other. You have certain set of measures, the commissioner, etc., and then if you fail, you can go to permanent court of arbitration. So that is how I think it works. It works similar to in water, environment, and it works similar in the climate case.
Yeah, I think you made it very clear, Mr. Siddiqui. Thank you for the answer. Mr. Siddiqui, finally, my last question is we discussed so many challenges and, but what is the actual scope of climate litigation, being that, it is a vital topic of research in the current years? And according to you, what is the ideal jurisdiction and influence of courts in assuring climate action in future?
See, I would see again, to my understanding, as I said, it emerges from the grassroots. And climate change is a very global issue. So the global plus local. So you might talk internationally and globally and come with the Paris Agreement or any other agreement. The action has to happen on the ground. So it is bit by bit, drop by drop. Unless ground level actions are not geared up, and countries do not do actions where it is required to be done. Merely having policies at the national or international level has not helped much, and there is a evidence to show that. So we have had, for example, the Kyoto Protocol for a long time. We have had the 1992 UNFCCC for a long time, and it took the world around 30 years to agree to a formula where somebody will do something differentially or as per INDC, so on and so forth. So to my understanding, the forum, the right forum, if at all you would require a forum, should be at the subnational level, because that is where we are talking climate action. I'll tell you the reason. The reason is, again, in the context of India, this is typical question which I often ask my students, the mid-level trainees, in fact, the forest officers and trainees in the Central Water Commission, so on and so forth, that where is environment mentioned in either of the three lists of the Constitution? So, in the Indian Constitution, as per the rules of business, we have three lists: the central list, the state list, and the concurrent list. So central list where center is empowered to make the laws, the state list where the state is empowered to make the laws, and concurrent where both state and center can make the laws. And if the center makes a state law in contradiction of that center law, is repugnant. So environment, you would be surprised to know, is not mentioned in either of the list under Indian Constitution. Neither is climate change. So, but the components of environment, which is land, water, forest, land. So forest is concurrent, land and water is state. Therefore, the most fundamental unit where climate preparedness has to happen, the most fundamental area where climate action and role of community and participation and ground implementation of SDGs have to happen. All the SDGs, the 6.5, 15, so on and so forth. All SDGs will have to come together at the local level, and the support will come from the state government, because that is the government which is directly in charge of legislating, decision making, and administration in those areas. And therefore, sub-national level, in fact, is the right forum for climate action, the policy making in the larger view, and supporting it to the grassroots level. And if at all there are claims that should be made at the sub-national level. Now, the way judiciary works in India, you have high courts in the states and you have a green court at the national level in India. After 2010, all the principles that the Supreme Court has mainstreamed or developed in India under Article 21 as part of environmental jurisprudence has been codified. So climate litigation, in fact, to my understanding, is a preparedness litigation, is a kind of a precautionary kind of a litigation, which invokes or provokes courts to think progressively, futuristically, and issue direction to the government to take certain measures, which somehow they have not been taken or are not able to take due to certain compulsions. There are many more political compulsions by which state policies, spin around. So there are reasons why states cannot do, though they mean to do many things. And they, in fact, are looking up to courts in certain areas. And there are instances where states are looking up to courts to give directions. One good case that I could recall as I'm talking at this moment is one judgment by the Supreme Court in one of the cases filed by I think Zinc Metals Limited or Zinc Industries Limited or something like that. The issue, however, was not related to zinc. The issue was there was this regulation passed by the State Electricity Regulatory Commission in Rajasthan on mandatory RPOs from renewable energy purchase obligations from renewable energy plants, solar or wind in Rajasthan. And that regulation was challenged by this company that I am naming. I'm not remembering the full name. It certainly had zinc, and the case was around 2015, I would say. And the argument there was that, government cannot force the purchase of RPOs or purchase of clean energy, and the thermal energy, the way it is going should be the way forward. Supreme Court upheld the regulation and said that in fact there is an obligation to buy RPOs because the obligation of the government is to lead the country to clean development mechanism and sustainable pathways and clean energy. So that's where I think the state governments are looking up to courts to give directions futuristically, and therefore the limitations so far expressed by the courts in many judgments that I cited by the Green Tribunal should be overcome. In fact, by invoking or looking at the National Climate Action Plan or the state climate action plans and push more government to do kind of climate action, which so far they have not been doing. So I think subnational level is a good area, and the National Green Tribunal, in fact, has been so far expressing their views, but has not been very clear and vocal in India on climate issues. So that's a handicap that should be overcome.
Thanks so much, Mr. Siddiqui, for your views. And it was wonderful talking to you today and listening to your insights. And I'm sure the audience must have benefited from the same. So thank you so much for joining us today. I would also like to thank everyone who decided to join a live session. Before we end, I would also like to inform everyone that the early bird registration for our upcoming conference, India Circular Economy Forum, to be held in New Delhi on the 2nd and 3rd of June, is ending tomorrow. So you may quickly register and book your seat for the same. We'll put the link to register in the chat box. So yes, we'll be back at the same time next week. And if you don't want to miss out on any updates or future conversations, do follow our social media pages and subscribe to our YouTube channel. Once again, thank you so much and see you next week at the Circular Chat. Thank you, Mr.
Thank you. Thank you, Susanna. Thank you for having me. Thanks a lot.